Welcome to Women in Wills, Estate Planning for Your Aging Parents. And I'm Liza Hanks. I'm an estate planning attorney. I practice in Mountain View, California. And I've been doing this for about 20 years. And I work with a lot of families of all ages, right? But it's not that uncommon that adult kids will contact me when their parents are starting to fall apart, looking for guidance on how to help them. And so I thought that this would be a good topic to address because it's a little bit falls in the cracks, right? It's not like the people that are contacting me, the people I'm thinking might be in this workshop are not the clients of a lawyer, but they're the concerned family members of older parents needing to figure out what to do. So this is what I was thinking about when I put this information together. So what I could offer people who are concerned about their parents or are anticipating needing to help their parents and trying to understand what they need to have in place. So I hope that's who you are. And my plan is to talk for maybe 20, 30 minutes. I have a presentation I'm going to walk through, and then just to answer questions, because questions are my favorite part of webinars and my favorite part of the talks I give to actual human people before the pandemic. So if you do have a question, put it in the chat, not in the chat, put it in the Q&A box, because that's what I'll see as I'm presenting. And there is a round glass expert in the background, Jessica, helping me. So she's going to be monitoring the chats too. Okay, so just to get started, let me share my screen with you. Okay. And let me just walk you through this. So here we are, we're trying to figure out what can we do for aging parents? What do they need? Right. So the first thing, hold on. The first thing you got to be is a detective, right? You've got to start with understanding what the heck your parents have already, if anything, in place, where they've stored it, and if you can get a copy. And this is not such a simple conversation for a lot of people to have, right? Because it's a real role reversal in some families, right? Because suddenly you're stepping into the potential role anyway of being the caregiver. And for some parents, this can be a really difficult conversation. They don't feel comfortable sharing information with you. They don't like getting older. They don't like thinking about needing help. Maybe they've never needed help before. You know, for other parents, it's like this incredible relief, right? Like, oh God, thank you. I don't know what I'm going to do when I get old and sick either. So we could talk about this together. And so, you know, there's a real spectrum of parents, you know, and how they will approach this and how they will feel about you asking them. But one gentle way that I found can help is to say, look, I need to know what you have so that when the time comes, I can help you stay independent, help take care of your needs, help communicate with your doctors, right? So this is me trying to help you. This is not me judging you. This is not me hectoring you or nagging you. This is like stepping up to say, when you need help, I want to be able to help you. That can be an effective approach. And another one that I didn't put in the slide, but it's kind of a sneaky way, is you can say, hey, mom, hey, dad, I'm actually doing my own estate planning right now. And that made me think, wow, we haven't had this conversation. Like, what do you have in place? So I hope that's helpful for some ideas. What you're looking for, if you're anticipating having to help an older parent, are two main documents. You need a power of attorney, a durable power of attorney, and an advanced healthcare directive. So let me talk a little bit about what these documents are, why you need them, how you can get them if your parents don't have them. So the first one is a durable power of attorney. So this is a document that appoints somebody called an agent to take care of a parent's financial things like bill paying, signing contracts for extended, like if you have to get somebody to skilled nursing or assisted living, home maintenance, retirement plans, credit cards, right? Any everyday financial task that someone has to do. If your parent, you know, has a stroke, or if your parent has dementia, or if your parent's in a car accident or has a heart attack, without this document, you can't do a whole lot. You know, you can't call the bank and release funds. You can't pay a credit card that comes due. When my father had a heart attack, I needed this document to go into his apartment. I had the landlord to let me into his apartment to get his clothes and stuff to take to the hospital. Actually, it's not true. I had a key, right? But if I didn't have a key, they wouldn't have legally been allowed to let me into his apartment without this document. I don't know where all of you are coming from, right? There are different parts of the country. And in some parts of the country, like where I practice, many people have a living trust, a revocable living trust, which is designed to avoid probate, which is a different class that I will be giving, and I've given already. I might be giving again. But anyway, that's the estate planning basics class. But what's relevant here is that if you live in a state where people do that kind of planning and your parents have a living trust, you still need a power of attorney. People get confused about this all the time. There are things in a trust and there are things outside of the trust. And people's lives span both of those things. So I will talk about that in a second. But before I do, there's two kinds of powers of attorney also. One is called an immediate power of attorney. It becomes effective upon signing. The minute your parent signs that thing, you could go ahead and do things for them. The other kind is called the springing power of attorney. Your parent would sign it, but you don't have any authority until it springs into action when they become incapacitated. Younger people tend to sign springing powers of attorney. Older people often sign immediate powers of attorney because they already know they want to have their kids in place to take care of things for them if they get sick. But you need to figure out which one you have if your parent has one, and it should say right at the beginning, this document is effective upon signing, or this document is effective upon the incapacity of the principal, that's your parent, and then it would define how that is determined. So if your parents have a living trust, what you need to understand is that if they become incapacitated, so they're not dead yet, right? They have a stroke, they have dementia, they're in a car accident. The assets that are held in the living trust would be managed on their behalf by what's called the successor trustee. But the agent under power of attorney is going to take care of all the stuff outside of the trust. And those are important things like everyday banking accounts, access to retirement accounts, checking accounts, credit cards, getting into an apartment. So you need to have both. It's not sufficient just to have one. Like a lot of people say, my parents have a trust. I don't know why I need a power of attorney. So this is why you need the power of attorney. If your parents don't have a trust, that's okay too. There are many states where people don't need living trusts because probate is relatively quick and inexpensive, like Washington State is one, New York State is another. So if they don't have a trust, you don't have this issue, right? You need the power of attorney to take care of their everyday finances if they get sick. But here's two gentle alternatives. If you have a parent who is going to need care and is uncomfortable with having their capacity determined in some way, you could ask them to make you a co-trustee now if you have a trust. And that way, if as they fall apart, you're already in place as a manager. It's a more gentle process. It doesn't require a letter from doctors saying your parents can't function. So that's one alternative. And if there isn't a trust, and a lot of people just do this anyway as they get older, they could make you a co-signer on a checking account so that if they go to the hospital, you can write checks for their rent, you can pay their doctors, you can take care of things. And the other thing is that many banks and institutions like Charles Schwab, Vanguard, Fidelity, they have their own internal power of attorney form. And if your parent signs that, at least with respect to those accounts, you will be able to act for them if they get sick. So those are alternatives to having a drafted power of attorney separate that may be helpful. Advanced healthcare directives have different names in different states. So where I practice, it's called an advanced healthcare directive. In some states, it's called a healthcare proxy. In other places, it's called a durable power of attorney for healthcare. So whatever you call it, they do the same thing. They appoint somebody to make medical decisions for the principal, that's your parent, if that person is not able to make an informed medical decision. And like that could be because they're unconscious. It also could be because they're just too doped up and confused, right? Or they could have cognitive decline such that they're not able to evaluate the pros and cons of a medical procedure. So in a situation like that, the agent steps in and makes these decisions like what doctor, what hospital, what procedure. And then In my state, California, they've combined something called the living will into the healthcare power of attorney. That's why it's called an advance directive. So we name an agent and your parent states their end of life choices. In some other states, it's a separate document called a living will. But the idea behind that is your parent, while they're competent and able to state their wishes, will say, you know, I do kept alive by artificial means. I don't want to be kept alive by artificial means. States vary in what those statements are allowed to encompass. It's very broad in California. You can say a lot of things like, I don't want to be treated even if it leads to my death, right? Like if you have ALS or Parkinson's or, you know, stage 4 cancer and you decide to terminate treatment, you have that right in California. You have that right in most states, but some states restrict some of the rights. Like if you're pregnant, you can't make some decisions in certain states. Not likely to happen to your parents though, right? So anyway, this is an important document, and you should have that in place for your parents as well. And you should have both of these like immediately available to you as your parents age. Because like I lived through this, you know, if you have a parent in declining health for 10, 15 years, and they regularly end up in the hospital, you just want to have this stuff handy so that like when you call the hospital and you say, how is my dad doing? If you get a nurse who knows what she's talking about, she'll say, I'm sorry, I can't give you that information without permission. And you say, not a problem. I'm his agent under power of attorney. I'm going to email you the healthcare directive or fax it over. And then you have permission to get medical information about your parents. So as they get older, you need to know where they are and need to have them handy. There are two other documents clients ask me about all the time, DNR and POLST. I don't know if they have different names in other states. I don't think they do. A DNR stands for do not resuscitate, and a POLST, physician order for life-sustaining treatment. It's a bright pink it has bright pink paper on the front usually. And these are things that you do with, your parent does with the doctor, not with a lawyer like me, in addition to an advance directive. And these are medically binding orders on physicians about the care your parent does and doesn't want. You will see these on refrigerators in people's homes that are ill, like a DNR. So if somebody with terminal cancer collapses in their house, they don't want the EMTs to come and shock them because it's a very, breaks ribs. It can be very invasive. It can be very traumatic for somebody who's already really sick and they're like, I don't want that. So they will put that on the refrigerator so that anybody who comes into the home will know. So if you have a parent who is terminally ill or really sick, it would be a good idea to ask them if they completed these documents as well. They go into their medical chart. Okay, so the idea behind them is doctors have not always been incredibly respectful of patients' wishes with respect to end-of-life care. And so these are like beefed up, yeah, I don't want this, or yeah, I do want this, that your doctor is supposed to respect when the time comes. So now I've talked some about the legal documents that you should have in place. And now I guess I want to talk a little bit about the real life ways in which these issues manifest themselves, right? Driving is a big one. Cognitive decline is a big one, and mobilities are big places where you start to see parents begin to fail, right? Driving can often happen first. Somebody gets lost on the way to the store. Somebody starts having car accidents. They didn't, like little fender benders they didn't used to have. Someone scrapes up the car parking. These can all be evidence of physical decline, right? They can be perceptual problems. They can be cognitive problems, and you shouldn't overlook them. And if you're concerned about your parents' ability to drive, you can take away their license. I mean, you can suggest to them it's not safe to drive anymore. And if you're really concerned, you can make them go to the DMV and take a test. But I just bring this up because often these are the first warning signs that we see. Mobility is another one. Oftentimes people will have a fall. They'll break a hip. They'll break a knee, they'll hurt a knee, they'll just lose their balance suddenly. And that can often be the beginning of the end for people, because it's also evidence sometimes of a beginning of a physical or cognitive decline. And then of course, cognitive decline, right? People's judgment will start slipping. I had a client who was a PhD at Stanford, smart person, long retired, who called me very excited because she was sure she had won the Publishers Weekly sweepstakes because she got a scam call from one of those people who tell you you've won. And all you need to do is like send them a check and you'll get all this money. She was really excited about it. And I was like, please don't do that. Don't answer the call. Don't believe what they're telling you. They're taking advantage of you. So so lottery scams are a sign often of beginning to lose judgment. Inability to manage finances is another one. So if you see somebody not paying their bills, not filing their taxes, not opening the mail, another sign that maybe you need to get them evaluated by a physician. It can get, what I'm trying to talk about are things that are a little less obvious, right? Than people forgetting words or people obviously ill, right? So mobility, cognitive decline, and driving are things that lawyers think about when we work with clients, because we can't have somebody, signing legal documents that doesn't have the capacity to do that. We're not doctors, of course, right? But we're looking for these things. Did they drive themselves to this appointment? Do they know what day it is? Do they know what we're doing? Do they know why we're doing it? And if the answer to any of those is no, we have to stop the meeting. So I hope this is helpful as just some warning signs to think about. A power of attorney, as I told you, is often effective upon incapacity. So how is that determined? So most legal documents will say you need a letter from 2 doctors, sometimes 3, stating that that person is unable to manage their own financial affairs or the affairs of daily living for healthcare. Some of these documents require specific kinds of doctors, like a neurologist. Most don't. Usually what happens is if you're concerned that your parent has really fallen apart, usually by that time they have doctors that are treating them, has been my experience. And if you go to the doctors, maybe a geriatrician, maybe a neurologist, and you say, is my mom capable of balancing a checkbook? Is my mom capable of driving? And often the answer is no. And it's not that hard to get a letter on the doctor's letterhead that just says, this is to certify that, Mrs. Jones is no longer capable of managing her own financial affairs. 2 of those letters attached to the power of attorney, and now you can act on behalf of your mom. It's usually the same incapacity determination for trust as well. So how do we determine a trustee is no longer capable of being a trustee? 2 letters from doctors is usually what you need, which is why I talked about some of those gentle alternatives, like, Mom, make me a co-trustee now. For some people, it's just a much more gentle way of acknowledging their decline. Like, they don't want to give up power. I mean, who does, right? They don't want 2 doctors saying that they're not capable. Who would? So some of these gentle alternatives I suggested are ways to negotiate this gray area between the parent who's completely on top of things and the parent who's completely not able to manage, so that when that time comes, you're already a manager, you're already in charge. And so we don't have to tell a parent they're not capable of doing it anymore. Just a little bit about things you should do and things you shouldn't do if you're trying to help an aging parent. It's fine to help them get their documents in order. It's fine if they don't have them. This is a link that Jessica's going to post in the chat. The AARP, they have a website. They have at this link, you can download a free healthcare directive for every state. That's a great resource for medical ones. For durable powers of attorney, so like in California where I practice, there's a California statutory form that you can download and print out. It's like 2 pages long, and your parents can check the box that says, I give the people all of these powers, and go sign it in front of a notary at a UPS store. So my point is, these don't have to be expensive lawyer drafted documents. There are other resources at EOL Collective as well, and I'm hoping Jessica can put some suggestions in the chat for putting together simple advanced directives and simple powers of attorney. If you want to do a will or a trust, that's where I think you get into the value that lawyers can bring to the process. But for these basic documents, you can put them in place for free or for very little money. How not to help your parents, okay? Please don't call an attorney and make an appointment for your parents and come to the appointment and pay the bill and ask all the questions. You've got to remember that if you're going to work with a lawyer, your parents are the clients. Adult children are not. And people get that wrong all the time. And then I have to say things like, you know what? I need you to step out of the room. I need to talk to your mom or dad alone. I need to make sure no one's putting pressure on them. I need to make sure that this is what they want to do. I'm doing that to protect your parents and you, actually, because if you have siblings who aren't at the meeting, who don't like what happened, I don't want them to undo the plan because they're going to say you made your parents do X, Y, and Z. So just be aware of the fact that if you're helping your parents, no matter how frail they seem to you, if you get a lawyer involved, the lawyer, if they're an ethical lawyer, should not answer your questions without your parents present or your parents' permission. Don't send me email. Don't send your lawyer email saying mom needs X, Y, and Z. What do I do? I just got that one yesterday. I had to answer it by copying mom and saying, Jerry just asked me how he can use your money to take care of you. And so you have to be aware of the fact that you need to be respectful of the privacy of your parents and the relationship between them and an attorney if you work with one. And then there's caregiving, right? You need to be having these conversations with your parents before they get sick, and with your siblings, I think, too, if you have them. You need to make a family plan for what's going to happen if somebody gets really, really sick. Do you need outside help? Should you start finding out what resources there are in your area for hospice care and for 24-hour care? Is there long-term insurance that your parents have? Probably not. Most people don't have it. Medi-Cal pays for some care, but it's not comprehensive and it's not at home. So you need to understand what you can do and what you can't do. And hospice, while it's a fantastic program, does not provide the care most people think it does. It provides nurses and doctors to come in a couple times a week to make sure that your loved one is not in pain and is comfortable. But they're not going to give that person a bath. They don't help them get to the bathroom. They're not going to do the laundry. They're not going to do the cooking. You're on the hook for that. Or you got to hire someone to help you with that. It is exhausting to be a caregiver of a really sick person. So I wanted to just put that, it's not a legal issue, it's a human issue, but I wanted to get that across to you today. And here's some places for resources for that. So there's something called the Family Caregiver Alliance. There's the AARP, and there's this link to Medicare and Medicaid basics, right? So Medicare is like health insurance for people over 65. Medicaid is for people who are poor. And like in California, where I practice, called Medi-Cal, it's not so easy to get poor enough to get the state to pick up your medical bills. And I don't do that kind of planning, but there are lawyers who do what's called Medicare planning. But basically, you have to start 5 years before that person needs to go into a nursing home if you want to get rid of assets, because there's a 5-year look back period, because the government is on to people who have resources, chucking them out the window and then saying they're poor enough for care. So it's something you really have to think about long before most families do. Most of the time they're thinking about this when their loved one's getting discharged from the hospital and going into skilled nursing. So too late, right? Too late to be poor enough to qualify for care. If that's your goal, you got to do it sooner. So that I'm going to end this screen share. Okay. And now I am super happy to answer any questions that people might have. So just put them in the Q&A, and I will answer them. Somebody be brave enough to ask a question. I'm pretty sure if you have it, other people do too. And now we wait. No questions? All right. I don't know what to do if we don't have any more questions. We could end early. We have a question. We have a brave volunteer. Do you suggest having separate agents for healthcare versus financial powers of attorney? From Marielle. And also thank you for asking. So here's what I think. It depends on, it depends on your family. It depends on the resources that a person has. There's no reason you can't name the same person. And people do that all the time, of course, right? Because so many estate plans are like, my son and daughter do everything. The reason to name different people, though, is if you have a nurse in the family, or you have a best friend who's a doctor, or somebody who you think, or your parents do. Sorry, I was thinking about you as the client. But if there's somebody in your family who would be better able to negotiate healthcare system on behalf of your parents, then they may be a better fit for healthcare. And if there's somebody in your family or in your circle of trusted people who is better at managing financial stuff or is super good at bill paying, then but not so good at like healthcare, then that would be a reason to have separate people. So I hope that's helpful. Here's another question. Good. And also I wanted to say that a durable power of attorney is the number one thing for which elder abuse happens, right? Somebody starts to fail, the evil gardener comes over and insinuates themselves into that person's life and then gets named as power of attorney and then like drains their checking account. So it's a blunt instrument. It's a powerful document. In the hands of the wrong person, it can do a lot of harm. So that's just something I wanted to get out there too. Okay, this is from the Reverend Greg Gurniak. Hi, Greg. If you are an only child who has no children, who would you recommend to have be a cosigner on a bank account or a power of attorney? So I think you're talking about for yourself, or maybe you're talking about people that you work with who don't have kids or any obvious people that would be able to step in if they get ill or sick. I have clients like that all the time. So for them, I would recommend somebody called a professional licensed fiduciary. I don't know if they have them in all states. They certainly do in California. I think they probably do. And these are people who are licensed by the state to act in the capacity of a fiduciary. A fiduciary is somebody who acts on the behalf of someone else. So a trustee is a fiduciary, the executor is a fiduciary, and your agents under powers of attorney are also fiduciaries. So so you can name these people, and then if you don't have kids or your kids aren't close by, to act for you in this capacity. So I would look for resources in your area for that. Okay. More brave people. Yes, for yourself. Okay. Hi, Greg. Well, yeah. So for you. So yeah, if you don't have trusted friends, if you don't have cousins or people in your life that you trust, then I would say maybe you need to get a professional fiduciary. And the thing is that like banks and trust companies, they will step in to be a trustee or an executor, but they often won't step in as a personal, like an agent under power of attorney or healthcare. So you can't really go to institutions usually for that. You have to go to individual people who are in that business for that. So I hope that helps. Okay, we need another volunteer. I'm just gonna sit here and wait till someone asks me a question. Or I can try to think of more helpful things to tell you about these issues. But somebody else must have a question. Okay, well then I'll think of something else to tell you that would be useful. Let me see. Well, related to Greg's question, thank you, TW. Can professional fiduciaries act in a way that's detrimental? Is this similar to a guardianship? Well, I mean, I guess the answer is yeah. I suppose a unethical professional fiduciary could do something unethical because you are giving these people, access to your finances. But they are also licensed by the state. So, it would be professional suicide for them to steal from you or to act in a way that's detrimental. And they could be removed for breach of fiduciary duty, and I'm sure they would be liable for any damages they made to you. I think the question and the fear is, what if there's nobody looking out on your behalf, right? I mean, these are those stories in the New Yorker a few years ago, like that scared the heck out of everybody, about people who were, forced into a guardianship by people who were like stealing from them. So I would say it's extremely rare. I would say that most of the people aren't doing that, and that they are under state supervision. Those guardianship stories, and how is this similar to a guardianship? So the answer there is a court appoints a guardian, or a conservator is what's called in my state, of somebody who is no longer capable of acting on their own behalf. People who get court appointed conservatorships are generally people who didn't do these powers of attorney when they had competence, right? So for example, my next door neighbor, when I first moved into this house 20 years ago, Johnny had dementia. They called it old timers disease, which I thought was adorable. And he was like physically capable of signing something, but he was not mentally capable of understanding what he was signing. And so I refused to do a power of attorney for that family. What that meant is that in order to pay Johnny's bills, to access Johnny's checking account, to make medical decisions for him, they would have had to go to court and have somebody appointed as a conservator, right? So this is a reason why you don't want to ignore these documents while while your parents have capacity. But once the person is appointed, that there is a judicial oversight. So again, I think that the fear of abuse in these situations is a bit overblown. The more typical abuse situation is the evil gardener, the girlfriend who sneaks her way into the 98-year-old guy's life and starts to take over his finances, because those are not supervised by anyone unless it's discovered. So that would be my fear more than a legal conservatorship or a guardianship. The other thing is that banks are, well, again, at least in my state, are mandated to report elder abuse if they think that it's happening, right? If somebody's cashing checks for somebody that never did that before, draining someone's checking account, they're required to report that to the police. Attorneys are required not to report that to anyone because we have a duty of confidentiality to our clients. But, if you have a parent who's being abused in that way, we would hope that the police would step in because somebody would report it. Okay, here's another question from Mariel. I noticed that the California Advanced Healthcare Directive document also includes a power of attorney within that document. So is it suggested to have a separate power of attorney for finances? I think I know the answer, but I just wanted to confirm it. Thank you. So the answer is they have the same name, but they're different things. There's a power of attorney for finance, and then there's a power of attorney for healthcare. So they have the same name, but they're for different purposes. So finance is a different section of the probate code. It gives somebody the power to do financial things. Healthcare is a different part of the probate code. It gives somebody power to do medical things. They have the same name. And then in California, the advanced directive, it has the power of attorney that we just talked about that says, I designate John to make decisions for me. And it states your end of life choices. And so it's packaged in a document called an advanced directive. So I hope that answers your question. Did I confirm it? Let me know. Inquiring minds want to know. I was going to say something else. I forgot what I was going to say. Oh, there are some questions coming in on the chat side of things. So let me take a look at that, okay, folks? Why do we wait to plan when old? This is a question. Oh, no, it's just something that I don't know what this is. Why do we wait to plan when we're old? Only 75% of Americans live beyond 65. Let's talk about death as part of life. I think these are some resources available at the EOL Collective. But I would encourage all of you to make your own plans. Something like 50% of this people in this country don't even make any plans at all, which is why the EOL Collective exists and why I like to do classes and provide resources for people, because the basics are not hard to put in place. You don't need a fancy lawyer to do them. You just need the will to get them done. So I'm happy to end early. If there aren't any more questions, I'm happy to wait a second to see if anybody would like to know any more. I appreciate you coming to this class. I hope it was helpful. I'm planning to do this every month for the entire year with different topics, and I hope to see you again. So if nobody else wants to ask a question, I'm glad you like the series. The next event is being posted. Also, I have a podcast. It's called Life, Death, Law, but it's changing its name to Women in Wills because I like that name so much. And I will start posting new episodes in the fall. And I hope I'll be able to let you know that through the EOL Collective as well. All right, then I will say goodbye and hope you have a good rest of your day from wherever you are. Take care and yeah, bye-bye.